Hello and welcome to AWANI Global. I'm your host Fana Shea, and today we're very excited to be at the sideline of the 38th Asia-Pacific Roundtable at Hilton, Kuala Lumpur. Now, today we're diving into shifting tides of maritime security, where law, politics and strategy intersects across the Asia-Pacific. And as regional tensions grow and legal norms are tested, how do we make sense of the contest for control, access and influence at sea? I'm very excited to have us. Joining us today is Professor Stuart Kaye, Director of the Australian National Centre for Ocean Resources and Security at the University of Wollongong. Thank you so much for joining us today.
Thank you very much.
Right, we just finished your session just now, so let's dive into the whole landscape of maritime security. Let's start at the very beginning, because we have time. How do different actors, you think, define maritime security? Let's start with that. I know it's very basic, but I think it's quite an important question to address, especially from a legal standpoint where you are. What do these varying perspectives reveal about the political and strategic undercurrents in this region?
Look, it is a complicated question, and it's one where there's no accepted definition that works for everybody in exactly the same way. Some states will look at it relatively narrowly and will look at interests very close to their coasts and want to make use of concepts of maritime security to deny access or to potentially deny access to certain waters. On the other hand, some states will take a much wider view and look at maritime security in a very holistic way, to say that maritime security is vital in terms of their overall trade and the like, where they want to make sure that there's freedom of navigation, so vessels can move about the world carrying all the goods that are needed to go hither and yon to help build wealth. States tend to be more of the latter approach than the former, but it's not universal by any means. And there are various international legal instruments that also are in this space. And they provide for various aspects of security to ensure that ports are free from interference and that vessels are well found and safe when they're navigating.
Right. So from what you're saying, there's the sort of the legal aspect of the definition, and there's also what states and regional actors, what they feel is the definition of maritime security. So from these differing interpretations, how has it evolved over time and what have contributed to today's fragmentation? So what are some of the most sort of striking contrasts if we talked about Western and regional actors conceptualizing maritime security?
Yeah. Look, I think there have been incidents that have occurred over time that have seen developments in the context of maritime security. The most famous one was a terrorist attack on an Italian cruise liner back in 1988. Where people had assumed that that sort of activity could be dealt with under the laws relating to piracy, but the definition of piracy didn't cover this particular incident. And so that led to a series of meetings in the International Maritime Organisation to try to firm up an international agreement that would deal with what was called the suppression of unlawful acts against maritime navigation. Never referred to terrorism anywhere in the document, but that was what it was directed at. Now that has been adopted in parts of the world, but it's not universally adopted here in Southeast Asia, and that imposes some limitations. Post 9/11, that agreement was substantially updated, and again the updating of that post 2005, relatively few states in Southeast Asia have gone for those further steps.
Right, so it's sort of like a lack of information of this evolvement or this differing definitions and differing legal aspect that not all states might understand and not all states are on board, you mean?
Well, also, to be able to implement obligations of this nature, there's work that needs to be done. And a state will need to work domestically within its national legislation to be ready to be able to do these things, and that requires some work and it requires some effort. And different states have different demands on their time and different capabilities, and so it may not be a reluctance to take these obligations on. It may simply be that there have been other more urgent things to do and limited capacity in which they can be done.
Right, I mean definitely in today's context with what's happening around the world right now, a lot of the attention shifting and people are focusing on different things, be it economy, be it global politics or international conflicts. So yeah, I understand what you mean. So let's focus on South China Sea. That was the big chunk of the discussion just now, and rightly so, because it's such a contested, it has been such a contested issue for so many times, for so many long years. So when we talk about South China Sea, how are competing legal claims like historic rights or interpretation of UNCLOS, for example, shaping the tensions there? Are we seeing a legal erosion of international maritime law?
Look, I don't think so. The issues in the South China Sea are complex,
right?
But at their heart, they revolve around issues of sovereignty.
Right.
That there are small features in the South China Sea, small outcrops of land that are just above the water. The largest is only tens of acres in size, so not very large features at all. And these features, the sovereignty is contested. And these are issues that can be found in other parts of the world. And in Malaysia, they had issues with respect to Ligatan and Sipadan Islands off the coast of Borneo with Indonesia that led to a case to the International Court of Justice. The issues in the South China Sea at their heart are exactly the same. Where they become more complicated is any feature will generate a certain area of maritime jurisdiction around it. It will give certain maritime rights. And the extent of those rights and the nature of those rights will be affected by the nature of the feature. And this is the subject of a significant dispute as well, because the Philippines took China to an international arbitration. China refused to participate. It said the arbitration shouldn't occur. And in that arbitration, the Philippines argued that the small features in the South China Sea would not generate large maritime zones. China's view is diametrically opposed to that. They think that the features can generate such zones. And this is at the heart of the dispute, because it's not just between the Philippines and China, but it also affects Malaysia, it affects Vietnam, and affects Brunei, and Taiwan, which isn't recognised by any of those, also has views in respect to it. So it makes it very complicated to try to unpick all these things.
Right, and also taking very long to sort of have any concrete dialogue up till now and concrete sort of solution or the light at the end of the tunnel when it comes to discussing on ways to resolve, sovereignty claim, which is something that is very, very complex, like you mentioned. So when we talk about naval power projections in the South China Sea, either by the US and China and regional actors, how are they shaping the strategic calculus? And do you think this region is entering a phase of low intensity but also constant friction that we see between Philippines and China, for example?
Look, there have been areas of friction that occur from time to time. What sets those off is usually determined by other factors. It may be a change in regime, for example. From the late 1990s through to the early years of Barack Obama's administration, the US and China often got into situations where there would be not so much a military confrontation, but efforts to try to, from the Chinese point of view, to discourage American vessels being in the vicinity, and the US holding the view that they had the right to be there. And those incidents would occur usually in the first few months, I should say, of a presidency in the United States. It was almost as if China was testing to see the resolve of the incoming president. That practice disappeared with the first election of Mr. Trump. They're perhaps a little uncertain as to what his reaction might be. But these sorts of things have gone on from time to time, and different states have faced different levels of discouragement and confrontation. And I'm not sure that there's much that's different now that could be described over the last 25 years or so. But there's better reporting, certainly a lot more media about it, and that's perhaps brought these issues more into the public eye than they might have been in earlier times.
Right. So I guess that let's move on to regional governance and legal framework, because this is somewhat the contested or the tensions, or what people are seeing could drive solutions, but are also critiquing it into either being in action or not serving its purpose, right? So ASEAN, we've talked a lot about ASEAN during the session just now, and ASEAN with members of with members with competing claims, has long tried to manage this space through consensus building, including efforts towards, establishing the code of conduct. So from a legal and diplomatic perspective, do you believe ASEAN still has the political space to act as a neutral convener, or is its credibility being tested?
Look, I think it's difficult for ASEAN. I'm not sure that ASEAN was ever intended to deal with disputes as difficult as these.
Right.
ASEAN works best when it's engaged in coordination and cooperation, particularly between the members. And in the maritime space, it's been quite effective in relation to that sort of cooperation. ASEAN has provided a focus with respect to the Code of Conduct negotiations that have been going on with China over the last 7 or so years. Level of progress is hard to assess because what goes on in those Code of Conduct negotiations is not public. But the progress has been slow. That's not a surprise. The issues are very, very difficult, even not to so much settle the dispute, but to settle how everyone should behave in the South China Sea is what the Code of Conduct is presumably aimed at. And so in those circumstances, ASEAN is doing its best to advance these things, and with what is a very difficult thing to do. And so I think in the circumstances, ASEAN's efforts are laudable. But will it necessarily succeed, and will we see a code of conduct emerge? I think that's not clear yet.
Right. I think from the discussion just now, the focus was, or the highlight of it was, ASEAN is not the ultimate solution provider. It's a mediator. And it's, like you said, it's doing its best. And I've heard an analyst say before, as long as we're not going to war with each other within ASEAN, I think it's still doing a good job at dialogue, at least. That's what an analyst said to me before. Right. So moving away from, looking at it more broadly, are international frameworks like UNCLOS, for example, still fit to purpose? Or are we due for an evolution in how global maritime laws address modern strategic behaviour, especially grey zone tactics?
Yeah. Look, I countenance against looking at changing things. The Law of the Sea Convention took a very, very long time to negotiate.
Right.
At the time it was concluded, it was the longest set of negotiations in international legal history. That's now been exceeded by the Doha round of the WTO, but even so, we're talking with the preparatory discussions well over a decade, and the actual negotiations in 17 separate sessions over nearly a decade. And it still doesn't settle everything in relation to maritime affairs. So having invested that much time, effort and energy, the international community, I think it would be most unwise to say, well, let's tear it up and start again, because you would be settling down for 20 or more years of effort when what we have deals with most things, and deals with most things reasonably well. Before the Law of the Sea Convention was concluded, there were nearly 40 states who asserted territorial seas that were much wider than the norm, more than 12 nautical miles wide. Today, nobody does. Everybody has a maximum of 12. And the Law of the Sea Convention has exerted a normative impact on state behaviour. Now, it was never intended to resolve all disputes, and so some types of issue remain unresolved. And some of these are prevalent in the South China Sea, particularly engaging in military activities or marine scientific research. These are areas which the Law of the Sea Convention either doesn't deal with or only deals with in a relatively limited way, and in a way in which the South China Sea is not best suited to see these issues resolved. So the convention won't solve all our problems,
right,
but throwing the whole thing out would be catastrophic. It would cause disruption in areas that are well settled and that work very well.
So if we circle back, do you still think it fits its purpose, or is it due, although it took a long time to get here, is it due for a revamp or a look into probably more complex issues or settling sovereignty claims, for example?
Well, the Law of the Sea Convention itself is in the form that it was in when it was first signed in 1982. But there have been 3 agreements concluded now, one yet to enter into force, that deal with additional issues that are designed to work with the convention. So the way you deal with issues that are emerging or issues that you would like to resolve is to add on, to put something else there. The most recent of these was only concluded in the last year or so, and that was to deal with protection of biodiversity beyond areas of national jurisdiction. And that agreement is yet to enter into force, but it's getting close and will enter into force soon. Before that, there was an agreement to deal with fisheries that were straddling the exclusive economic zone and the high seas, or deal with highly migratory fish stocks. And those are ways that you can help improve the Law of the Sea Convention, make it more responsive and more alive to these sorts of concerns. There's talk that the next iteration of all of this will be in the context of dealing with marine plastic pollution, because that's a terrible scourge, and certainly in Southeast Asia and other places, it's a big ecological problem. So an international agreement that provided for stronger protections to stop marine plastic pollution would be very positive. When it gets to issues like those that might be found in the South China Sea, I'm not sure that there'll be a huge diplomatic effort to resolve these in the short term or even in the medium term.
Right.
They're complex issues, and it will be an effort that I'm not sure the international community is quite ready for.
So it takes more than international law, basically, to solve it. It takes political will, dialogue, and sort of states' willingness to sort of sit down and discuss possible solution, right?
Well, that's the way international law gets made. For the most part, it's derived from treaties and conventions, or from what's called customary international law, which is essentially state behaviour, as well as their belief that the law is binding upon them. But mostly, it's treaties and international agreements that give rise to it, and that, by definition, requires political will at the very highest levels of government.
Right. So I guess if I can throw you this, you know, states are hardening their maritime postures, you know, building bases, asserting EEZs, and, you know, reinforcing FONOPs, for example. Do you think the idea of global commons at sea is losing its ground to hard sovereignty and security competition?
Look, I think the answer is a yes and a no. I'd say no, because if you consider the volume of international trade that passes through Southeast Asia, that trade is going through waters which are under the sovereignty of some states. A vessel making a voyage from the Mediterranean through the Straits of Malacca and then up to China or Japan is going to pass through half a dozen states' areas of sovereignty in their territorial seas. And those voyages are being made largely without interference and without difficulty. So to that extent, I think the law of the sea is robust, and sovereignty claims aren't stopping that key area. But we do see evidence that there are places where states are concerned, particularly about warships and warship transits, and that can lead to areas of tension. But that sort of activity has been going on for a long time. And to some extent, although we see instances of tension, it doesn't always lead to conflict.
Right.
And so to that extent, mostly states have been able to rein themselves in. In some parts of the South China Sea, that's been difficult though. And confrontations between China and the Philippines have been quite robust. But to date, as far as I'm aware, without loss of life. But even so, there's tension there, and that's something which ultimately the two states will need to manage.
Right, so you're saying there's flashpoints and there's tensions at certain areas, contested areas like South China Sea, for example, but in general, trade is still ongoing, cooperation is still there, states are still abiding to some sort of global commons when it comes to, you know, maritime security.
Yeah. Look, ocean space on some levels is shared space. To be able to get from Malaysia to Europe, you have to pass through somebody else's territorial sea, or you have a very long voyage ahead, and one that is not the most direct. In those circumstances, some level of cooperation, some level of common use has been understood for a very long time, and rights of innocent passage, special rights of passage through straits and archipelagos have long been accepted by the international community. And so to that extent, there are protections there for the things that we need. But when states face off against each other with sovereignty claims, where these are contested, backing down may have a detrimental effect on their claim. So that can lead to where you have tension and some robust exchanges, and it explains why states are very reluctant to back down.
Right. I mean, we can sit here all day and discuss the solutions to South China Sea, but you know it's not going to go anywhere. So let's continue with what contribution we can take with Track 2 diplomacy, for example. So what role can Track 2 diplomacy, like the APR conference, for example, in contested maritime spaces, what role do they play? Are there examples, say, the Indian Ocean or even the South China Sea, where informal or non-state engagements have moved the needle?
Look, there have been efforts that have worked to try to help in the South China Sea. Certainly the Canadian government provided support through the 1990s into the early 2000s to efforts that were principally made within the region to try to have Track 2 discussions. Indonesia is very involved in Track 2 discussions and even Track 1.5 discussions in relation to the South China Sea through the 90s and into the 2000s and beyond. So there are a lot of goodwill to try to help in this regard, and certainly while there's discussion taking place, while there's constructive discussion, then it does lead to hope. Events like this one have diplomatic attendees, and they listen, they may get ideas, and so Track 2 work can be very helpful in helping sow some seeds that may lead to discussions around where cooperation might be possible and chip away against these difficult issues.
Right, we're basically throwing the seeds around the garden, but the house is still occupied by those who are in contest with each other, and they are the ones who need to solve the problems in the house.
Ultimately, yes. These are matters that have to be resolved ultimately at the very highest levels of government. These are things for presidents and prime ministers to ultimately make the decision and to decide what level of solution might be possible. But getting help from this kind of forum is very useful because it can give ideas for where cooperation might be possible and help push things along.
Right. It's a nice way of looking at it. So I guess looking ahead, do you think we're heading towards a more fragmented maritime order in the Indo-Pacific or Asia-Pacific? Or are there still potential to strengthen the rule-based order through regional or multilateral efforts?
Look, I think there's still potential to do good things. I think the Law of the Sea Convention and some of the other instruments associated with it provide for opportunities at cooperation. Cooperation in relation to things like search and rescue or responding to a large oil spill. These are things which states can do which are in everybody's interest to respond to, where cooperation is relatively low-hanging fruit, doesn't require giving up sovereignty claims, doesn't require difficulties having to be resolved. And then if you can proceed incrementally, you can get some way along. And once cooperation is taking place, then it becomes easier. One of the things that's being promoted at the moment, particularly by the UN through its Food and Agriculture Organisation, is what's called the Port State Measures Agreement, which is designed to deal with illegal fishing, but it does so rather than arresting fishing vessels on the sea, setting minimum standards for fishing vessels to be able to come into ports. And if everybody cooperates in that way, then you can help stop illegal fishing. Now that measure doesn't require anybody to get concerned about sovereignty claims or arresting vessels at sea, and it is a good way to cooperate. And there's been slow but increasing take-up of this Port State Measures Agreement in Southeast Asia, and I think that's a very positive development.
I mean, it's those low-hanging fruits that you talk about, you know, those areas of cooperation that you can agree on, and you can just move forward and let, you know, the big boys handle the big stuff. we can handle the little stuff, and sooner or later it will accumulate to something even bigger, right?
Well, cooperation, I like to think, is a bit of a reflex. That once you start to cooperate with a neighbour, you begin to find greater common cause.
More common grounds.
And everything can work a little better.
Yeah,
and so to that extent, I think states, if they cooperate where they can, then it makes it easier to find solutions to more difficult issues down the track.
Right. I think that's a nice way to wrap up this discussion. Thank you so much, Professor, for your time. And that brings us to the end of today's conversation. Now we remember maritime security isn't just about ships and sovereignty. It's about rules, cooperation, how we navigate contested spaces together. A big thank you for you, Professor Stuart Kaye, for sharing your insights and deep expertise with us. That's all from me. I'm Fana Shea. Thank you for watching.